Generative AI has transformed the landscape of creative industries. Image and text generators such as Stable Diffusion, Midjourney, DALL-E 2, and ChatGPT 3 can create stunning visuals in styles ranging from old-aged photographs, watercolors, pencil drawings, as well as writing essays, poems, and summaries that mimic styles and forms of some of our best authors. Generative AI platforms are trained on data lakes consisting of billions of parameters constructed by software processing vast archives of images and text. However, the legal implications of using generative AI, particularly in relation to intellectual property infringement, are still unclear and pose significant risks for businesses and individuals that adopt this technology. Generative AI is new to the market, but existing IP laws have significant implications for its use. One of the key issues is what constitutes a derivative work under IP law and whether AI-generated works are sufficiently transformative from original works to avoid these infringement cases. Getty, an image licensing service, filed a lawsuit against the creators of Stable Diffusion, alleging the improper use of its photos, violating copyright and trademark rights. In each of these cases, the legal system is being asked to clarify the bounds of what is a derivative work under IP, with many different jurisdictions having different interpretations. The outcome of these cases is expected to hinge on the interpretation of the fair use doctrine, which allows copyrighted work to be used without the owner's permission for purposes such as criticism, including satire, comment, news reporting, teaching, including multiple copies for classroom use, and scholarship and the like. The fair use doctrine has been used successfully as a defense in other technological cases involving copyright, such as when the Google Books case, where Google scanned and digitized millions of copyrighted books for its digital library, arguing that it was a transformative use.